talk about this Supreme Court ruling, shall we? Donald Trump petitioner versus Norma Anderson et al. Pure curiam. What is that? This is where we want to start off with. Pure curiam. This is the Supreme Court saying we don't have the balls, we don't have the guts, we don't have the integrity to tell you who wrote this. Except we know it's none of the liberals that wrote this. So we just have to guess who wrote this. I was looking forward it to be another horrible Alito ruling, but we'll see. So Kalahela Hubba Bubba calls him daddy. Hilarious. So, just the summary. A group of Colorado voters contends that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald Trump, who seeks presidential nomination, from becoming president. The Colorado Supreme Court agreed in order to Colorado Secretary of State to exclude the former president from Republican primary ballot in the state and to disregard write-in votes that Colorado voters might cast. Former President Trump challenges that decision on several grounds, because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates. We reverse. So last September, on March 5th, we know the history of it. Let's see, President Trump disrupted peaceful crowd, blah, blah, blah. One consequence of those actions, the respondents maintain, is that former President Trump is constitutionally ineligible to serve. Their theory turns on Section 3 of the 14th Amendment. Section 3 provides no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may vote by a 2/3 of each house to remove such a disability. According to the respondents, Section 3 applies to the former president because after taking a presidential oath, he initially incited the breaching of the Capitol in order to retain power. They claim he is therefore not a qualified candidate, and that as a result, the Colorado Secretary of State may not place him on the ballot. After a 5-day trial, in the state district court found the former President Trump had engaged in insurrection within the meaning of Section 3, but nonetheless denied the respondent's petition. The court held that Section 3 did not apply because the presidency does not mention by name, Section 3 does not mention by name, is not an office under the United States, and that the president is not an officer of the United States within the meaning of that provision. In December, the Colorado Supreme Court reversed in part and affirmed in part by a 4-3 vote, reversing the district court's holding. The majority concluded that for purposes of Section 3, the presidency is an office under the United States. The court otherwise affirmed, holding that the Colorado Election Code permitted the respondent's challenge based on Section 3, that Congress need not pass implementing legislation for disqualifications in order for Section 3 to attach, that the political question doctrine did not preclude judicial review of the former President Trump's eligibility, that the district court did not abuse its discretion in admitting into evidence portions of congressional report on the events of January 6th, that the district court did not err in concluding that those events constituted an insurrection, and that former President Trump engaged in that insurrection, and that former President Trump's speech to the crowd that breached the Capitol was not protected by the First Amendment. Colorado Supreme Court accordingly ordered Secretary Griswold to not list the President Trump's name on the primary ballot or count any write-ins cast for him. Chief Justice Boatwright and Justices Samore and Burton Cotter each filed dissenting opinions under the terms of the opinion of the Supreme Court. The ruling was automatically stayed pending this court's review. We granted the former President Trump's petition for certiorari, which raised a single question: did the Colorado Supreme Court err in ordering President Trump excluded from the ballot? Concluding that it did, we now reverse. Dun dun dun. So, proposed by Congress in 1866 and ratified in 1868, the 14th Amendment expanded federal power at the expense of state autonomy and thus fundamentally altered the balance of state and federal power struck by the Constitution. Okay, I mean, I would expect a conservative to write that. Section 1 of the amendment, for instance, bars the state from depriving any person of life, liberty, or property without due process of law. denying any person equal protection of the law, and Section 5 confers on Congress the power to enforce those prohibitions along with other provisions of the amendment by appropriate legislation. Section 3 of the amendment likewise restricts state autonomy, but through different means. It was designed to help ensure enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. Statement of Rep. Stevens warning that without appropriate constitutional reforms, yelling secessionists and hissing copperheads would take seats in the House. Statement of Senator Howard lamenting prospect of a state legislature made up entirely of disloyal elements absent a disqualification provision. Section 3 aimed to prevent such a resurgence by barring from office those who, having once taken an oath of office to support the Constitution, afterward went into rebellion against the government. Section 3 works by imposing on certain individuals a preventive and severe penalty of disqualification from holding a wide array of offices rather than by granting rights to all. It is therefore necessary, as Chief Justice Chase concluded, and the Colorado Supreme Court itself recognized, to ascertain what particular individuals are embraced by the provision. Chase wanted to explain that to accomplish this ascertainment and ensure effective results, proceedings, evidence, decisions, and enforcements, more or less formal, are indispensable. For its part, the Colorado Supreme Court also concluded that there must be some sort of determination that Section 3 applies to a particular person before the disqualification holds meaning. The Constitution empowers Congress to prescribe how those determinations should be made. Does it? We'll get into that. The relevant provisions in Section 5, which enables Congress, subject to a course of judicial review, to pass appropriate legislation to enforce the 14th Amendment, or as Senator Howard put it at the time of the amendment, Section 5 casts upon Congress the reasonability of seeing to it for the future that all sections of the amendment are carried out in good faith. Now, Section 3 specifically states that Congress can take away the impediment, right? So we'll go into this Section 5 of it, but Section 3 gives Congress the ability to, with a 2/3 vote, to take away the impediment. Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation less than a year after ratification, Senator Trumbull noted that notwithstanding hundreds of men were holding office in violations of its terms, the Constitution, Trumbull noted, provided no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. The enforcement mechanism Trumbull championed was later enacted as part of the Enforcement Act of 1870, pursuant to the power conferred with the Fifth of the 14th Amendment. This case raises the questions whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. Now, why? I'm sure they might try and explain why, but if they're going to argue that Section 5 of the 14th Amendment makes it so that Congress has to pass the law in order for somebody to be barred, let alone ignoring the fact that Section 3 says that Congress only has to do something to undo the barring, then how can a state then in any way have any authority to do anything if it's Congress that has to be the one that proposes laws to enforce any part of the 14th Amendment? So right then and there, they've contradicted themselves. Not surprising, because it's an activist conservative Supreme Court. In our federal system, the national government possesses only limited powers. The states and the people retain the remainder. Among those retained powers is the power of the state to process its own governance. In particular, the states enjoy sovereign power to prescribe the qualifications of their own officers and the manner of their election, free from external interference, except for the fact that the Constitution specifically states that you cannot serve a state office if you participated in insurrection or rebellion against the federal government, or if you gave aid and comfort to those people who did so. So clearly, the 14th Amendment, while stripping away powers of the states in in the first part of the section of the 14th Amendment by requiring that the states can't deny life, liberty, or property, by saying that they have to guarantee equal protection under the law, due process to individuals, right? All of that applies. And yes, the Congress can make laws to make sure that the states aren't, denying people those rights, i.e. that's why we have hate crime legislation. That's how the federal government was able to come in and prosecute the individuals who murdered the civil rights workers in Philadelphia, Mississippi, who were murdered because Mississippi wouldn't do anything about it. So the federal government came in using the legislation that was passed under the Civil Rights Act to basically say, hey, this is a violation. These people's civil rights were violated, so therefore we're going to charge you with the federal law because the state has no longer protected you because you're supposed to have protection or equal protection under the law. So although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states the traditional authority, except for the fact that it clearly states that people have the authority that only Congress can undo the ability of somebody who has had an insurrection. Only Congress can pass a law that can undo the prohibition of somebody who has committed an act of insurrection against the country. So a state cannot undo somebody's authority, somebody's prohibition, so to speak, right? That's plain language. They're manufacturing language out of the air, which is why we're calling this an activist conservative Supreme Court. After this ratification, the 14th Amendment states use this authority to disqualify state officers in accordance with state statutes. But should they have been able to appeal to tradition is a logical fallacy. It is not a reasonable argument to make. Just because they did something doesn't mean they did it right. Such power over governance, however, does not extend to federal office holders and candidates because federal officers owe their existence and functions to the united voice of the whole, not of the portion of the people. No, the federal office holders, i.e. Congress people, owe their offices to the whole of the people who elected them, which come from those specific states. So only people from Colorado are electing people from Colorado. So if you're a congressperson from Colorado, you're only being elected from Colorado. If you're a senator from Colorado, you're only being elected from Colorado. And the people who are electors, who are going to the Electoral College to vote for President Trump or for President Biden, or any other presidential candidate, I guess, that's out there that they're voted for to go vote for in the Electoral College, they're all from Colorado. They're all elected representatives from Colorado. Because remember, it's not the people who choose the president. The people choose the electors. The elector chooses the president. But I guess the Electoral College is inconvenient to them in this argument. Such power over governance, however, does not extend to federal office holder candidates because federal officers owe their existence, blah, blah, blah. Nothing in the Constitution delegates to the states any power to enforce Section 3 against federal office holders and candidates. But you're making the argument that only Congress can do it, but they've just then made the argument that the states can do it for state office holders when the amendment is clear that state office holders are prohibited from running if they're insurrectionists. So that would mean that the federal government would have to have all the power if you're going to go by your logic, by whoever wrote this majority opinion. I would, again, bet dollars to donuts that this was Alito. This had to be Alito. No way that this wasn't Alito. As an initial matter, it does not even the respondents contend that the Constitution authorizes states to somehow remove sitting federal office holders who may be violating Section 3. Such a power would flout the principle of the constitutional guarantees, the entire independence of the general government from any control of representative states. Indeed, consistent with the principle, states lack even the lesser powers to issue writs of mandamus against federal officials or to grant habeas corpus relief to persons in federal custody. That has the ability to not grant habeas corpus to people in federal custody has nothing to do with this. Why this is being brought up here is absurd, and another reason why I'm fairly certain that this is written by Alito, because this is already a terrible ruling. The respondents nonetheless maintain that states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. The terms of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. And I'd buy that. I would buy that argument that Section 5 requires that Congress could enact legislation to enforce it, but because you're now saying that the states can prohibit their own insurrectionists on their own based off of Section 3 of the 14th Amendment, then you've just contradicted yourself. So we're not any clearer as to what the meaning is if you're going to hold on to the position that these states can use the insurrection clause of the 14th Amendment to ban state office holders while stating that only Congress can do it because of Section 5. It doesn't make any sense, Alito, and I'm standing firm that this was written by Alito. Maybe he was just embarrassed after having written so many other bad rulings that he didn't want to put his name on this bad ruling as well. This can hardly come as a surprise given that the substantive provisions of the amendment embody significant limitations on state authority. Under the amendment, states cannot abridge privileges or immunities, deprive persons of life, liberty, or property without due process. But he had due process. There was a trial. There was a court case, and the court said you can't be on the ballot. Denied equal protection or deny male inhabitants the right to vote without thereby suffering reduced representation in the House. On the other hand, the 14th Amendment grants new power to Congress to enforce the provisions of the amendment against the states. It would be incongruous to read that the particular amendment is granting states the power silently, no less, to disqualify a candidate from federal office. So no, so the states, so Congress can pass laws to restrict the states from violating the 14th Amendment. That doesn't necessarily mean that the states don't have the authority to yeet people from the ballot if they are insurrectionists. But again, if you're going to take the stance that the Supreme Court took, that only Congress has the ability to do it, you can't then say, except for state elections. It has to be all or nothing. You either have to say only Congress can prescribe the means in which office holders are prohibited from the ballot as insurrectionists, regardless of its state or federal, or states can do it. It's not states can do it under some circumstances, but not under others. Because again, the states are responsible for their own elections, so states are responsible. It's the same thing for gerrymandering. You can't argue that gerrymandering is not something that you're going to get involved with because it's up to the states to deal with. Yet with gerrymandering, you're denying the ability of the people to have equal protection under the law because you're denying them the power of the vote by restricting the power of their votes, by shoving minorities, for example, into districts that do not allow them to have as much say as the other people in their state. And if somebody's calling, I see if somebody's calling. I don't see my screen. I don't see the call screen right now, so we're not taking calls at the moment. The only other plausible constitutional sources of such delegation are the elections and electors clauses, which authorize states to conduct and regulate congressional and presidential elections, respectively. But there's little reason to think that these clauses implicitly authorize the states to enforce Section 3 against federal office holders or candidates. Well, I mean, look. If a state can decide to gerrymander their congressional districts and then award electors via those gerrymandered congressional districts, then why wouldn't a state be able to then enforce Section 3. If states have on federal candidates for federal office who are representing that state, but they can do it for the state office holders. It makes no logical sense. There's no logical sense here. The text of Section 3 enforces these conclusions. Its final sentence empowers Congress to remove the disability by a 2/3 vote of each house. The text imposes no limits on that power. Congress may exercise at any time at the respondents' concede. Yes, Congress can, with a 2/3 vote of each house, remove the inability of somebody to run for office by a 2/3 vote of each house. That doesn't mean anything about who is ineligible from the get-go. If you're an insurrectionist, you're an insurrectionist, regardless of whether or not. Insurrectionists can't run for office. Period. That's the end of story. If you're an insurrectionist, if you committed an act of insurrection, which it was ruled that Donald Trump did, and the Supreme Court of Colorado confirmed that, then you can't be on the ballot. See, in fact, historically, Congress sometimes exercised this amnesty power post-election to ensure that some of its people's chosen candidates would take office. But if states were free to enforce Section 3 by barring candidates from running in the first place, Congress would be forced to exercise its disability removal power before voting begins if it wished for its decision to have any effect on the current election cycle. Oh, boo-hoo. Then force them to do it. Just because, so you're crying because Congress has to put in extra work? Oh, no. Again, it's an illogical argument, which is why I'm sure this was written by Alito. Perhaps a state may burden congressional authority in such a way when it exercises its exclusive sovereign power over its own state offices. Again, yeah. So, if somebody wants to run for state office, and a state goes, this person's an insurrectionist, he can't run for governor. Only Congress has the authority to remove that. So Congress would have to act before the election to remove that inability to run for office. So if you're going to cry about it on the federal level, you need to cry about it at the state level too. It doesn't make any sense. This ruling is not consistent. But it is implausible to suppose that the Constitution affirmatively delegated to the states the authority to impose such a burden on congressional power with respect to candidates for federal office. Why? Just because you say it doesn't mean it's true. States have no power to retard, impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress. But this isn't them enacting this has nothing to do with the constitutional laws enacted by Congress. This isn't a law enacted by Congress. This is the Constitution in and of itself. Constitution in and of itself says, you're an insurrectionist, you can't serve. Done. Period. Nor have the respondents identified any tradition of state enforcement of section... Yeah, there you go. They haven't recognized a tradition. Who does appeals to tradition? A lot in their rulings. Sam Alito. Again, this is another proof in the pudding that Sam Alito wrote this damn ruling. That he didn't have the guts to attach his name to it. Nor have the respondents identified any tradition of state enforcement of Section 3 against federal officers for candidates in years following ratification. Just because it didn't happen doesn't mean it doesn't exist. Appeal to tradition is a logical fallacy. Such a lack of historical precedent is generally a telling indication of a severe constitutional problem with the asserted power. And it is an especially telling sign here because, as noted, states did disqualify persons from holding state offices following ratification of the 14th Amendment, which means they're able to do so. And nobody challenged the state's ability to do so. So states have the authority to disqualify people from the ballot if they are insurrectionists. Done. So there's your tradition. If you want to make your appeal to tradition, there's your tradition. That states have the authority. That pattern of disqualification restrict to state but not federal offices provides persuasive evidence of a general understanding that states lack the enforcement power with respect to the latter. No, that's stupid. Instead, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders. Shortly after ratification, Congress enacted the Enforcement Act of 1870. That act authorized federal district attorneys to bring civil actions in federal court to remove anyone holding non-legislative office, federal, state. So remove anybody, not to prohibit anybody, to remove anybody holding non-legislative offices, federal or state. So yes, they made the law for non-legislative office holders because that's the only way you could do it. You can't, a state has no ability to remove a non-legislative office holder because the state doesn't control how those office holders are picked. So again, these people, these non-legislative office holders, have nothing to do with elections to Congress or elections to the presidency. Why? Because the people who are non-legislative office holders aren't picked by the voters. So therefore the states have no ability to control how federal ones are selected. But states do have the authority to control how office holders are selected within their states. They run the elections, and that's a tradition that has been a tale as old as time. In the years following ratification, House and Senate exercised unique powers under Article 1 to adjudicate challenges contending that certain prospective or sitting members could not take retained seats due to Section 3, and the Confiscation Act of 1962, which predated Section 3, effectively provided an additional procedure for enforcing disqualification. Well, why are you bringing up the Confiscation Act if it has nothing to do with Section 3? Nothing to do with the Section 3 that we're talking about. It has no place in the ruling, Alito. That law made engaging in insurrection or rebellion, among other acts of federal crime, punishable by disqualification from holding office under the United States. A successor to those provisions remains on the books today. Moreover, permitting state enforcement of Section 3 against federal office holders and candidates would raise serious questions about the scope of that power. Section 5 limits congressional legislation enforcing Section 3 because Section 5 is strictly remedial. To comply with that limitation, Congress must tailor its legislative scheme to remedying or preventing the specific conduct the relevant prohibition prohibits. Section 3, unlike other provisions in the 14th Amendment, prescribes conduct of individuals. It bars persons from holding office after taking a qualifying oath and then engaging in insurrection or rebellion, nothing more. Any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870, reflect congruence and proportionality between preventing or remedying that conduct and the means adopted to that end. Neither we nor the respondents are aware of any other legislation by Congress to enforce Section 3. And that would be fine if they just left it there, honestly. I would buy the argument if not for the fact that they're saying, except the states can do it for the state-run people. States can bar people from running from office based on Section 3, but not for people running from their states for federal office. It doesn't make any sense. Any state enforces Section 3 against federal office holder candidates that were not derived from Section 5, which confers power only to Congress. As a result, such states are going to sweep more broadly than congressional enforcement could under our precedents. But the notion that the Constitution grants the states freer reign than Congress to decide how Section 3 should be enforced with respect to federal offices is simply impossible. But then it shouldn't apply to state offices either. Because if only Congress has the authority to undo the prohibition of an individual who has committed an act of insurrection, then the state has no say in it by their arguments. But again, their arguments are fallacious at their core. Finally, the state enforcement of Section 3 with respect to the presidency would raise heightened concerns in the context of a presidential election. State-imposed restrictions implicate a uniquely important national interest, but state-by-state resolution of the question of whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents all the voters in the nation. The president represents the electors who elect him, and the states are in charge of the process in which those electors are selected. Conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, but from the variations of state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some might allow Section 3 challenge to succeed based on a preponderance of the evidence, while others might require a heightened showing. Okay, but states are responsible for having their own elections. You know what the answer is? Don't insurrect. Don't commit acts of insurrection or treason against the country, and you won't have to worry about it. Certain evidence, like congressional report on which the lower courts relied here, might be admissible in some states, but admissible in hearsay in others. Disqualification might be possible only through criminal prosecution as opposed to expedited civil proceedings in particular states. Indeed, in some states, unlike Colorado or Maine, where the Secretary of State recently issued an order excluding the former president from the ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could well be that a single candidate would be declared ineligible in some states but not others based on the same conduct and perhaps even the same factual record. Okay, so either then Congress under the article under the 14th Amendment has the ability to say, okay, well, we're just going to take the inability of this person to run from office away from this person so that person can be on all the ballots, thus preventing the states from banning this individual person from running for office. Right? That's the power that was granted to the federal government by Section 3. The patchwork wouldn't exist if you didn't commit an act of insurrection against the country. And just because some states are willing to be apologists for an insurrectionist, that doesn't make it okay to force other states to not remove insurrectionists from the ballot. And even if you wanted to agree that the states shouldn't be able to do it for the presidency, it still doesn't mean that they shouldn't be able to do it for the congressional and senatorial office holders. Because again, the states run those elections. And that wouldn't have any patchwork because that would only be specific to those states. The patchwork that would be the likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. The founders didn't have such a great history on what the people and the power of the people would have. But in a presidential election, the impact of the votes cast in each state affected by the votes cast, or in this case, the votes not allowed to be cast for various candidates in other states, an evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. This disruption would all the more be all the more acute and could nullify the votes of millions and change the election result. Well, that's what the Electoral College does. It nullifies the votes of millions by creating like 5 to 10 states that are actually, in play, and the rest of them aren't. My vote counts for shit in the Electoral College. So our founding fathers created a system where only a few states matter. So this argument, again, is specious at best. If Section 3 enforcement were attempted after the nation has voted, nothing in the Constitution requires that we endure such chaos, arriving at any time for different times up into perhaps beyond the inauguration. Well, if you're inaugurated, the only way you can remove a sitting president from the inauguration is to impeach. Now, granted, if you have a 2/3 vote in both houses that's willing to say you're not qualified for the office, you also have a 2/3 vote in both houses to impeach somebody in the House and to convict on articles of impeachment in the Senate. So the 2/3 thing is not really relevant there because you could just impeach and remove and boom, there you go, you're done. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of Colorado Supreme Court is therefore cannot stand. All 9 members of the court agree with the result. Our colleagues writing separately further agree with many of the reasons this opinion provides for reaching it. See Post Part 1 joining Sotomayor, Kagan, and Jackson, and see Post Page 1 opinion of Barrett. So far as we can tell, they object only to our taking into account the distinctive way Section 3 works, and that the fact that these Section 5 vests in Congress the power to enforce it. These are not the only reasons the state lacked the power to enforce the particular constitutional provisions with respect to federal offices, but they are important ones, and it is not the combination of all the reasons set forth in this opinion, not as some of our colleagues would have it, just one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment the court unanimously reaches. The judgment of the Colorado Supreme Court is reversed. The mandate shall issue forthwith. It is so ordered. So there you go. That's the horrible ruling that is, I am still saying that is written by Alito because it is a terribly written ruling. Maybe not the worst one he's written, but it's horribly written. So, let's see what Justice Barrett has to say. She concurs in part, and concurring in the judgment. I join parts 1 and 2 of the court's opinion. I agree that the states lack the power to enforce Section 3 against presidential candidates. That principle is sufficient to resolve this case. I would decide no more than that. This suit was brought by Colorado voters under state law and state court. It does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. The majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election, particularly in this circumstance. Writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the messages Americans should take home. So not a very expansive thing written by Barrett, but at least it doesn't make the arguments that one I'm assuming is Alito made, which is that only the Congress can do this except for when it's the states doing it. Like, it doesn't make any sense. Alito. All right, so Sotomayor, Kagan, and Jackson concurring in judgment. It is not necessary to decide more to dispose of a case than it is necessary not to decide more. Dobbs v. Jackson. They're citing Dobbs v. Jackson. Usually it's Kagan that does this, but Sotomayor is, I guess it's Sotomayor that wrote this because it's, maybe they all wrote it together. I don't know. That fundamental principle of judicial restraint is practically as old as our republic. The court is authorized to say what the law is only because those who apply a rule to particular cases must of necessity expound and interpret that rule. Marbury versus Madison. Today the court departs from that vital principle, deciding not just this case but challenges that might arise in the future. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist and therefore disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principles. This is enough to resolve the case. Yet the majority goes further. Even though all 9 members of the court agree that this independent and sufficient rationale resolves the case, the 5 justices go on. They decide novel constitutional questions to insulate this court and petitioner from future controversy. Although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. The majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily. We can only concur in the judgment. Our Constitution leaves some questions to the states while committing others to the federal government. Federalism principles embedded in the constitutional structure decide this case. States cannot use their control over the ballot to undermine the national government. States' restrictions in that case implicate a uniquely important national interest extending beyond a state's own borders. No doubt states have significant authority over presidential electors and in turn presidential elections. That power, however, is limited by other constitutional restraints, including federalism. The majority rests on such principles when it explains why Colorado cannot take the petitioner off the ballot. State-by-state resolution of the question would be quite unlikely to yield a uniform answer consistent to the basic principle that the president represents all the voters of the nation. That is especially so, but so does the Electoral College. Again, the Electoral College makes it so that the president doesn't represent all of the people of the nation. We have a split nation where many people don't have a say because people in my state of Louisiana will vote for Trump and my vote counts for nothing. The contrary conclusion that a handful of officials in a few states could decide the nation's next president would be especially surprising with respect to Section 3. The Reconstruction Amendments were specifically designed as an expansion of federal power and an intrusion over state sovereignty. Section 3 marked the first time the Constitution placed substantive limits on a state's authority to choose its own officials. Given that context, it would defy logic for Section 3 to give states new powers to determine who may have the presidency. Okay, I can buy that argument. If they would have just said that, I'd be done with it. Fine. But again, Sotomayor and Kagan and Jackson, those justices are intelligent human beings, and Alito is a dumb pile of rocks. To provide the secure, sufficient basis to resolve the case, to allow Colorado to take presidential candidate off the ballot under Section 3 would imperil the framers' vision of a federal government directly responsible to the people. The court should have started and ended its opinion with this conclusion, yet the court continues to resolve questions not before us. That's why it is an activist conservative Supreme Court, because it is taking on more than what was asked of it and is spreading its wings, so to speak, to talk about things that weren't before them. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed. Congress, the majority said, must enact legislation under Section 5 prescribing the procedures to ascertain what particular individuals should be disqualified. These musings are inadequately supported as they are gratuitous. Nothing in Section 3's text support the majority's view of how federal disqualification efforts must operate. Section 3 simply states that no person shall hold certain positions or offices if they are oath-breaking insurrectionists. Nothing in that unequivocal bar suggests that implementing legislation enacted under Section 5 is critical for that matter, or for that matter that the word means in this context. In fact, the text cuts the opposite way. Section 3 provides that when an oath-breaking insurrectionist is disqualified, Congress may, by a vote of 2/3, remove such a disability. It's hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing or declining to pass implementing legislation. Even petitioner's lawyer acknowledged the tension in Section 3 that the majority's view creates. Similarly, nothing else in the rest of the 14th Amendment supports the majority view. Section 5 gives Congress the power to enforce by appropriate legislation. Remedial legislation of any kind, however, is not required. All the Reconstruction Amendments, including the Due Process and Equal Protection Guarantees and Prohibition of Slavery, are self-executing, meaning they do not depend on legislation. Similarly, other constitutional rules of disqualification, like the 2-term limit of presidency, do not require implementing legislation, nor does the majority suggest otherwise. It simply creates a special rule for the insurrection disability in Section 3. The majority is left with next to no support for its requirement that Section 3 disqualification can occur only pursuant to legislation. It cites Griffin's case, but that is non-precedential lower court opinion by a single justice in his capacity as a circuit judge. Once again, even the petitioner's lawyer distanced himself from fully embracing this case as probative of Section 3's meaning. The majority also cites Senator Trumbull's statements that provided no means for enforcing itself. The majority, however, neglects to mention that Senator's view is that the 14th Amendment that prevents a person from holding office with the proposed legislation simply affording more efficient and speedy remedy for effecting disqualification. So basically, they took his words out of context and ignored the rest, not shocked. Ultimately, under the guise of providing a more complete explanation, the majority resolves many unsettled questions about Section 3 and forecloses judicial enforcement of that provision, just as might occur when a party is prosecuted by an insurrectionist and raises the defense of that score. The majority further holds that any legislation to enforce this provision must be tailored to Section 3 at 10, ruling out enforcement under federal statutes requiring government to comply with the law. By resolving these and other questions, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal offices. What it does today, the court should have left undone. The court, Breyer and Bush v. Gore dissenting. The court today needed to resolve only a single question. The majority resolves much more than that. Section 3 serves its important, though rarely needed, role in our democracy. The American people have the power to vote for and elect candidates for national office. The men who drafted and ratified the 14th Amendment had witnessed an insurrection and rebellion to defend slavery. They wanted to ensure that those who participated in an insurrection and possible future insurrections could not return to prominent roles. Today, the majority goes beyond the necessities of the case to limit how Section 3 can bar an oath-breaking insurrectionist, Trump, from becoming a president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define what limits to federal enforcement of the provision. Because we would only decide this issue before us, we concur only in the judgment. So there you go. So basically, just to go over that, I mean, that was probably the shortest review of a Supreme Court ruling that we've ever done. But basically, just to go over, just to review, the three lefties on the Supreme Court are right in that they only should have been going over whether or not President Trump could be barred from, or whether or not a state could bar any presidential candidate from running for office as an insurrectionist. That question could have been answered and settled, and I might have agreed with the opinion if they just would have left it at that. But they went on to opine and have opinions about other things that were not at all related to what this case was about. And as they say, potentially what it does is to protect future insurrectionists from punishment, i.e. from not being able to run for office. They also repeat the line that many experts have said, which is that the amendment in and of itself, all of the post-slavery amendments are, self-implementing, i.e. if you are an insurrectionist, you can't be on the ballot. It's just not up to the states to figure that out. Now, they didn't go on to talk about the weirdness of how the majority, i.e. Alito, as my opinion at least, says that the federal government can only do it unless it's a state election, then the state can do it, even though the federal government is the only one with the authority to do it because of the Section 5 of the 14th Amendment. So they didn't touch that one. I wouldn't want to touch that one with a 10-foot pole either if I was one of them, but because they were trying to stick their comments only to why they didn't want to talk about the rest and why we should only talk about this, that, and the other. We should only talk about the presidential candidates being barred by states who believe that the person running is a insurrectionist. Now, do I agree with it? I might have accepted the argument. Doesn't necessarily mean I would have agreed with it, but I might have accepted the argument because, according to the, let me pull this other thing back up real quick. I had it pulled up. Because the 14th Amendment does say, Section 5, Congress shall have the power to enforce by appropriate legislation the provisions of this article. To enforce it, so basically saying, okay, when normally the states would have the power, it grants Congress the power to have the by appropriate legislation the provisions of this article. So let's flip back to here again. So Section 3, again, no person shall be a senator or representative in Congress or an elector or president, vice president, blah, 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 or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may vote by 2/3 of each house to remove such disability. So, if they would have just said, only because Congress has the ability to enforce this to enforce these powers or these 14th Amendment sections, that therefore they're not powers granted to the states by the 10th Amendment, and as such, only Congress can write legislation to enforce this. They would just left it at that and not expounded and expanded their beliefs and expanded their commentary on other issues that were not before the court. I would have been like, all right, fine, I'll accept that argument. Because that's kind of a plain language type deal. But they didn't. They went further. They went further than they needed to. Again, to protect Herr Trump. To protect the insurrectionist in chief. So, and that's what we're stuck with. We are stuck with this activist conservative Supreme Court. Thank you, all the people who are all worried about Hillary's emails, but her emails. They didn't want to elect Hillary Clinton. They didn't come out and vote. We lost the right to body autonomy in Dobbs v. Jackson. We lost the control of the Supreme Court. We lost a lot of things under Donald Trump. And now we have whiny people who are risking another Trump presidency. And it's sad that that one of the few hopes that we have is that for all the people that are saying that I voted for Biden last time, I'm not voting for Biden this time, you have a bunch of other people who are voting for Nikki Haley who are never going to vote for Trump, who understand the importance of defeating Donald Trump, and who might very well come out and vote for Biden and undo the harm that is caused by those people who, in states that matter, are going to stay home or vote third party or in otherwise take an action that, as I covered in my previous Fat Man rant, punishes Joe Biden. We have an insurrectionist running for office. That wasn't ever undone. The ruling by the Colorado Supreme Court specifically stated and confirmed that Donald Trump is an insurrectionist. And that was not undone by this ruling. This ruling, while it did go on to expound about other things that were not related to this case, it only, for the parts of the Colorado case that was important, it only discussed his ability to be on the ballot. It didn't discuss whether or not he was an insurrectionist or not. So according to the state of Colorado, it was found that he was an insurrectionist, that he participated in an insurrection. And I'll fully agree with the ruling from the state of Colorado. And other states have also formed that opinion as well. So anybody voting for this asshat is voting for an insurrectionist.